Okay, I believe we are ready to commence our next case. We are now going to hear the argument for Benskin versus West Bank. Benskin is represented by Steve DeVolder. Mr. DeVolder, can you hear me?
I can, Your Honor.
Thank you. And versus West Bank, represented by Dennis Ogden. Mr. Ogden, can you hear me as well?
Yes, Your Honor.
Thank you. The clock is one of the screens here in front of you, and it's the same clock from our typical oral arguments. So, Mr. Ogden, you may begin.
Thank you, Your Honor. May it please the court, counsel. My client is West Bank. They're the applicant here and greatly appreciate the opportunity to engage in oral argument on this case, Your Honor. This case filed by Benskin centers on two loans that were made by West Bank to Benskin Inc. The first one is an October 24, 2007 loan, or actually is a line of credit. West Bank agreed to give or provide to Benskin up to $2 million to purchase development land in Dickinson County, according to the allegations of the petition. And that line of credit was secured with mortgages in Dickinson County and Polk County, among other things, according to the allegations. And Benskin claims that it did not ever use the line of credit. That loan matured on May 30th of 2008. And the allegations of the petition, and specifically paragraph 9 on page 26 of the appendix, is that on that date, West Bank was obligated to release the mortgages, and specifically we're dealing with the Polk County mortgages that are at issue here. And then the allegation is that West Bank did not release those mortgages, and that is the first breach that occurred. A second loan that was made earlier than the first loan we talked about was a loan on October 6th of 2006. That loan was secured by a promissory note, and that was West Bank loaned $800,000 approximately to Benskin, that was secured by Dickinson County mortgages, but not Polk County mortgages. The note was initially due in 2007, but it was renewed on August 1st of 2007. And so it had a maturity date of August 1, 2008. The allegation in the petition is that sometime between October 24 of 2007, when the second loan was issued, and August 1 of 2008, when that loan matured, West Bank internally altered its records to pay off the October 6, 2006 loan, the $800,000 loan, without Benskin's authorization. And that is the second breach that is referred to in the petition.
Mr. Ogden,
Yes.
This is Justice McDonald. My question is, what would be wrong with allowing discovery or development of the equitable estoppel claim? And that's not a comment on the merits of the statute of limitations, affirmative defense, or the equitable estoppel, but why not allow some discovery so that claim can be developed?
Well, there are two reasons that I would say. Basically, first, under Iowa law, under the Christie versus Muley case and Mormon versus Iowa Workforce Development and some other cases, the defendant must be alleged to have done some affirmative act to conceal the plaintiff's cause of action, independent of and subsequent to the liability producing conduct. There is no allegation in the petition of any such conduct. As an example, in the Mormon case, the court brought up examples like telling someone who you discriminated against on the basis of age that you had actually gotten rid of their position, or that you downsized the workforce or whatever. So you're making an affirmative allegation that is false, that you didn't really do that. You just told them that, and that caused them not to bring their claim because they thought, oh, shoot, if they did that, I don't.
Mr. Ogden, this is, go ahead.
Just one follow-up. Thank you, Justice Mason. What stage of litigation were those two cases in? Because it seems like the general rule is that a plaintiff doesn't have to plead information to overcome an affirmative defense. And you would not disagree, would you, that your client bears the burden on the affirmative defense, a statute of limitations?
Well, I guess I'm not sure what you mean by an affirmative defense, but what they're trying to do here is they're trying to say that even though the statute of limitations would prevent their claim because they didn't bring it in time. I mean, these claims were brought roughly 10 years after the liability producing contract.
I guess what I mean is, to my understanding at least, that the statute of limitations is an affirmative defense, correct?
Yes, it is an affirmative defense, sure.
And so in the cases that you cited, at what stage of litigation were those involved? Were those summary judgment? Was the statute of limitations issue tried, or was it on motion to dismiss?
I don't believe either of those cases. Well, actually, the Mormon case, I believe, was a motion to dismiss. I don't recall whether Christie versus Muley was, but I believe that the Mormon case was a motion to dismiss.
So yeah, I want to keep following up on that, Mr. Ogden. So if statute of limitations is an affirmative defense, equitable estoppel is kind of an affirmative defense to an affirmative defense, right?
Correct.
So kind of shifts the burden back to them. Now, what they've said in their petition is West Bank's fraud, concealment, misrepresentation, and deception induced plaintiff to refrain from bringing action. So I guess my question is, I know you don't have to plead fraud with specificity, but is that degree of generality enough? Are those legal conclusions enough to get past a motion to dismiss and get them into discovery? Or do they have to plead something more than just, 4 legal terms?
Well, and I will say, Your Honor, no, I don't think they are enough. But also in this situation, the allegations that were made about these general things also referred to the allegations that were made earlier in the petition. So in other words, what they were saying was the things we said earlier were the fraud and deception and all of that stuff. And so they're referring back specifically to the actions that were taken that breached the contracts. So they're not alleging any subsequent action. They're just.
Let me ask another question if I could. You talk about the entry being changed on the bank records. What if the West Bank actually didn't change the entry on the bank records to show that the 2007 loan paid off the 2006 loan? What if they hadn't done that until, say, 2015? You would agree in that case that the lawsuit's timely, right?
I guess I'd have to think about that. One of the reasons I feel like this lawsuit is not timely is because if they paid off the note in 2008, okay, if they paid it off before August 1 of 2008, then Benskin would have had to have known that they paid off the note.
Yeah, I see what you're saying. I'm just saying, I'm just trying to think, as the standard is there any set of facts under which they would be able to prove their case and prevail on it? And my question is that a possible set of factual scenario, or is that simply inconsistent with the petition?
Yeah, I think it's inconsistent with the petition from my perspective. And also I think you need to look at the statute, because the statute refers to a breach. Okay, when did the breach happen? If you look at 524-221-2, it says that if a breach occurs in a written contract with a bank, then the accrual of your claim is 1 year after the breach. Okay, it doesn't say anything about equitable estoppel or any of this other stuff. It says your accrual is 1 year after the breach. And in this situation, the breaches were obvious. The breaches were obvious because they didn't release the mortgages on May 30, 2008, which they were obligated to do according to the petition. And
Counsel, I'd like to follow up on and explain my one of my main concerns about whether dismissal was appropriate here. Paragraph 12 alleges that the bank in June of 2011 expressly refused to release the mortgage. Why didn't that stop the clock or start the clock running on all the theories of breach, or is this misuse of the line of credit a separate element of damages?
Well, if you assume that those facts have any meaning in this situation, which I don't assume, but if you assume that, then what we're saying here is, here's a guy who gets a commercial loan. He's got 2 commercial loans for almost $3 million, okay? He's supposed to have his mortgages released in May of 2008. And he's now saying, I sat around for 3 years and listened to these guys tell me that they were going to release my mortgages. For 3 years he did that, over 3 years. And then they said, oh, well, guess what? We're not going to release your mortgages. Ha, ha, ha. Okay? From my perspective, it's not reasonable for him to have sat around for 3 years and listened to them say they were going to release mortgages when they were already in breach in May of 2008. So number one, it's not reasonable to do that. But secondly, even if you run the date from June of 2011, you're still too late. You're still
Okay,
too
let me shift to the slander of title. Why wouldn't the filing on a public docket of an encumbrance that, if you assume it's should have been removed, why isn't that publication?
Well, number one, there's no allegation that it was filed, that it was recorded. There's nowhere in this petition that it says these mortgages were recorded. We're just supposed to assume that, okay? And so nowhere do they.
Can we assume that on notice pleading principles? You have a general idea of what the claim is?
They allege the opposite. What they alleged is that they concealed these facts. They concealed these facts from them, and they didn't figure it out until after they sued us in July of 2016. So they're actually alleging the opposite of publication. They're alleging that we kept it from everyone.
What is the statute of limitations for slander of title?
I believe it's 5 years.
Let me ask a question on that.
522 or 524.22, since this involves the, a state bank.
Well, I guess I don't relate it. The statute relates to a contract and or an entry or a bank entry.
Okay.
It doesn't relate to, mortgage or something like that.
Okay, and I'm sorry, I trampled on one of my colleagues' questions.
No, I was going to raise the same thing. Why doesn't the slander of title claim fall under 524.22 as well? I mean, if the basis for the slander is, if the slander is a claim that's inconsistent with an entry in a state bank record, which is what you're saying, isn't it? You're saying his whole claim is inconsistent with entries on West Bank's internal records, right?
I haven't looked at it that way, and no one argued that.
Okay. All right.
Well, you did argue the statute of limitations on slander of title in district court and again on appeal, correct? So that's alternative ground. We could affirm the dismissal of that count, right?
Yes.
Okay.
So is on slander of title are you arguing statute of limitations or not?
Actually, no, I didn't argue statute of limitations on slander of title. I argued that they didn't allege a publication, and in fact, they alleged the opposite.
I saw in your trial court briefing an alternative argument of statute of limitations, and it was mentioned again on page 13 of your red brief. Are you now giving up that argument, or is it an alternative ground we can use to affirm? Which?
Well, I'll be honest with you, I didn't read that part of it. So if I made that argument, I want to keep it, but I don't recall doing it.
You may wrap up.
All right, well, I think our argument is that if you read the petition, it shows on its face, without question, that these claims, all of them, are beyond the statute of limitations. And with respect to the slander of title claim, it does not allege publication, which is a necessary element of slander of title, and therefore all of the claims should be dismissed.
Thank you. Mr. DeVolder.
Chief Justice, and may it please the court, the question in this case, at least for the first 4 of the 5 claims, is did the district court err, or conversely, did the Court of Appeals get it correct when applying the demanding Rule 1.421F motion to dismiss standard for failure to state a claim, particularly in the context of an affirmative defense where my client Benskin does not have the burden of proof. What we do plead—
Counsel, let me interrupt you on that point. Don't you have the burden, or your client have the burden, of establishing an equitable estoppel or discovery rule exception to the statute of limitations, which from the 4 corners of your petition, the breach is 2008. You know, you're coming up on 10 years later when you file in May of 2018.
But we don't claim in the petition or in the briefing that the breach was 2008. You're referring, Your Honor, to the maturity date of the line of credit of May 30th, 2008. But according to Benskin, as pled and as argued in this case, what do we have? Benskin is in the dark concerning what the bank had done earlier, that is, tap into the line of credit without Benskin's approval, authority, or even notice to him. Benskin believes, as of May 30th of 2008, and realistically under the petition, that the amount of the lien secured by the mortgage is 0. I mean, there may facially be a mortgage listed, for example, let's focus on the Polk County properties because those are the additional collateralization. But in Benskin's eyes, it was 0. 0, when does an accrual, the word accrual means you have an existing cause of action. Your cause of action doesn't accrue until, among other things, for contract breach, fraud, or whatever the case may be, you have causation in damages. While at most there was a paper filing on the Polk County, the mortgage actually encumbered a 0 amount of value on that 2008 mortgage. And that puts into context the affirmative misrepresentations then from there by the bank. Of course, Mr. Benskin did ask, following that 2008 date, hey, let's, get these mortgages released. And for 3 years, until June 27th of 2011, the bank said, sure, we'll get it done, we'll do it. He's still sitting at a zero value on the mortgage in his mind.
So when in June of 2011, when the bank says we're not going to release that encumbrance, why didn't that put your client on inquiry notice of wrongdoing?
Let's say it did, right? Let's
Okay.
say that the date, I'm going to make a twofold answer to it. But let's just say for purposes of my first point, June 27th of 2001, perhaps Benskin should have been on inquiry notice. That in fact, did he have something here concerning the value of these mortgages that he didn't know he had? Well, under the relevant banking statute, he had 1 year for that claim to accrue, which puts it on June of 2012, and then another 6 years, which pushes us to June 27th of 2018, and he had filed his petition before that date. But secondly, the bank's fraud on this, or the bank's misrepresentation, was twofold. When the bank told Benskin, under the pleading standard of failure to state a claim, the bank did not tell him that the reason the bank was not going to release the mortgage, the Polk County mortgages, is the best way to describe it, was, despite its other promises, was the bank gave him no reason. The bank at that time did not say, well, here's the deal, Mr. Benskin. Actually, we tapped into that credit line, and the bank did without your authorization, and accordingly, the mortgages no longer have a facial zero value. And conduct is a statement under the law. The bank took conduct and it hid that conduct from Mr. Benskin. What Mr. Benskin did find out of what happened occurred back up in July 22 of 2016, and as pled in the petition, when discovery from other litigation between the parties revealed what the bank had done.
How was your client harmed by that breach that was revealed in 2016? Was it the failure to remove the encumbrance?
Well, there's one clear on 2016. There's one clear harm on the loan on the earlier loan, the 2006 loan, which the bank tapped in to pay. That loan was not secured by Polk County Real Estate. For the bank to get its hands on additional value, collateral value from Mr. Benskin, by tapping in wrongly, Your Honor, to the 2007 line of credit, the bank increased its security at the direct financial harm. Its supposed customer, Mr. Benskin.
Mr. DeVolder, I want to get back to the actual breaches. Doesn't your client claim that the actual breaches themselves would have happened in 2008?
The breach, one of the two breaches clearly did. And Your Honor, that breach was the bank's wrongfully tapping in to the credit line to pay off the 2006 loan. I'll concede that, Your Honor, you're dead right. But the question is, how was Benskin supposed to know that, at least under the facts that we've pled? Now, we may speculate, and it's all speculation for purposes of motion to dismiss, that maybe he should have known it. But we can't speculate as to what facts may be disclosed ultimately as this case progresses. And there's a wealth of Supreme Court.
All right. And what about, and you said when the other breach you're claiming is what, and when would that have occurred?
Well, the other breach we're claiming is, when you go back to the other breach we're claiming, of course, is the bank's lies on promises that they would release the Polk County mortgages, which occurred up until June 27th of 2011.
But didn't it start earlier? I mean, didn't they breach earlier by not releasing? I'm putting aside the equitable arguments. I'm just trying to understand when the breaches occurred.
Well, if you're saying that the bank had breached earlier by not releasing on loan maturity date, again, we have to keep in mind that you're at best talking about maturity of a loan of zero. I mean, you know, the first thing that I would have probably gotten asked, at least by the top court, you know, if Benskin would have sued in 2008 to demand the lease of the paper mortgages under the bank's promises that it would do so, where's your damages? The mortgages have a zero value. At least Benskin reasonably thought. Now, granted, it turned out.
Mr. DeVolder, this is Justice Actually. I just want to ask you on that point, even though it had a balance of zero, it was a $2 million line of credit. Had they gone to another bank isn't going to loan them more money when that line of credit is available because they could have used it at any time. So how can you say that that's no harm?
You're asking me that Benskin could have tapped into the line of credit?
I'm just saying that you're saying that there's no harm because it had a zero balance, but the line of credit was still available, I guess is my point. So I'm asking about the harm, why that still is no harm just because it has a zero balance, but the mortgage still exists.
Well, I don't know. The line of credit matured in 2008. Matured generally means that the transaction is over. Perhaps if Benskin would have decided to do so, it could have gone back to West Bank or any other bank, as you suggest, and try to start up a line of credit transaction. But recall under the pleaded facts, Chief Justice, that the line of credit was for the potential of Benskin acquiring and developing property in Dickinson County. And that project never went through.
Here, I mean, all right, if we assume that the breaches occurred, the two breaches occurred in 2008, and then you have sort of fairly specific allegations that cover the period from 2008 to 2011, where in those allegations, you say, well, the bank was reassuring my client that the mortgages were going to be released, et cetera, et cetera. But once we get past 2011, all you have are just sort of these conclusions: fraud, concealment, misrepresentation, and deception. How are those conclusions sufficient to buy the additional time, assuming you could work some kind of equitable estoppel exception? How do those get you all the way up to 2018?
Okay, under the banking statute of 524.2212, if the claim accrued on June 27th of 2011, when you read the statute, there's a grace period of 1 year from accrual to when your 6 years from the date of that 1 year extension apply. So you're at 7 years. That pushes at least those claims to 2018. Now, what you must be referring to after that is probably the fraud claim, which indeed does have a 5-year statute of limitations. But with respect to the fraud, I mean, the real act here had to do with the bank's conduct, and conduct is a statement of tapping into that credit line. And the bank, by saying we're not going to release the Polk County mortgages, did not inform Benskin of the reason why they were not going to release those mortgages.
All right, getting back to 524.22, what do you make of this sort of strange language where there's 1 year till it accrues, and then you have 6 years to file? If we say it accrued in 2009, then you add I see what you add 6 years from 2011. I mean, you need 7 years, don't you?
Correct.
You need 7 years from 2011.
If this is the relevant statute, but that is correct. You need 7 years from June 27, 2011.
Okay.
But shouldn't our Counsel, shouldn't that run from 2008 when they should have released the encumbrance? I mean, I don't want to talk in circles, but let me ask you a legal question on the interpretation of 524-221-2. Does the wording of that statute allow for a discovery rule? And just last spring in a Midwest One Bank versus Heartland Co-op, we interpreted a different statute where it had a specific accrual date to say no discovery rule allowed. Why shouldn't we reach the same interpretation here and say you don't get a discovery rule extension? You get at most the 6 or 7 years from the breach.
The statute singularly uses, for purposes of your question, the word accrue.
Okay.
It doesn't have any limitation on, by the legislature in writing that statute, that the word accrue in that statute has some different meaning. If you go to the general limitation statutes, Your Honor, of 614.1, likewise, those statutes use the term accrue. But there's nothing in this statute language-wise which would suggest that the term accrue is being used in a special limiting meaning when that's the only word that occurs in this statute.
Well, no, I would disagree with that. It says shall be deemed to have accrued and shall accrue for purpose of the statute of limitations 1 year after the breach. That's pretty specific.
Well, even on the general breach statute, it accrues from the time of the breach. But for accrual, we're not suggesting that you need to know you have a complete cause of action, and the discovery rule can extend that, let alone equitable estoppel. All it's saying is, to me, perhaps you and I disagree, Your Honor, it's got the rather mundane language for any breach of contract action that it accrues on the breach.
Don't interpret anything from my questions, please.
I apologize. That's true.
No, don't apologize either. Just don't worry about my questions.
You're almost out of time, but I wanted to ask you, if we conclude the statute of limitations alternative argument is still in play, what is the statute of limitations for slander of title?
Well, in this case, it would be the 524-221, because it was based on the alteration of the bank's records when the bank, without authorization and in direct interest against its client, tapped into that line of credit.
And that happened. I know you alleged you discovered it in 2016, but that alleged misconduct happened in 2007 or 2008, right?
It would have occurred in 2008, shortly before, as pledged, shortly before the 2006 maturity occurred, which was August 1st, 2008.
And I understand that there were some assurances spoken by the bank that lulled your client into not filing, but the last of those was June of 2011. Did the bank communicate anything affirmatively after that date to cause you or your client to hold off on filing suit? Or was it just a continuing concealment claim?
It was continuing concealment, but also you've got to put yourself in Benskin's shoes as pled in this. While the bank's saying we're not going to release the mortgages, still at that time on June 27th of 2011, Benskin had no clue that the mortgage had any lien value on his Polk County property beyond $0 and 0 cents. And the bank did not inform him otherwise.
You may wrap up.
I will just go to one more comment with respect to, I know you asked the alternative statute of limitations ground on the slander title. But with respect to publication, there's no question that these mortgages were recorded and not released. And the purpose of the recordation statute is to give notice to third parties all third parties that would be interested of the mortgage. That's publication.
Thank you. Mr. Ogden, do you have a response? We can't hear you. You're still muted. I'm just
Sorry.
happy to see I'm not the only one who did it today. Thank you, Mr. Ogden. You may
I'm
proceed.
an old guy. This technology is totally not my thing.
That's
But
okay.
anyway,
Go ahead.
Let me give you a couple of thoughts. First of all, he said they didn't claim a breach in 2008. That's absolutely wrong. If you look at paragraph 9 of the petition, of the amended and substituted petition, it says that West Bank was obligated to release the 2007 mortgages in May of 2008. If that's not an allegation that they breached it when they didn't do it, I don't know what is. And they certainly claimed a breach after that, and they didn't claim that the breach happened at any other time. They're trying to get the best of both worlds here and decide when the breach happens themselves, I guess. But they allege
Mr. Ogden, let me kind of try and summarize Mr. DeVolder's position as I understand it. Essentially what he says is 524.22 establishes something like a 7-year statute of limitations from the breach. Even assuming the breach occurred in 2008, there's some specific allegations in the petition that the bank made promises that discouraged him from filing suit at least through June of 2011. You add 7 years to that, you're past the statute of limitations. I mean, the suit is timely. What's wrong with that argument?
Well, what's wrong with it is that the statute doesn't permit it. As you've noted, and as you've all picked up, the statute says nothing about accrual based on a discovery rule or anything like that. And in fact, if you read the whole statute, if you read the first, one of the reasons 524.221 was enacted the way it was because in the first paragraph, they changed the amount of time that banks have to keep records from 10 years to 7 years. So the point of this was to change the period of time that they would have to respond to claims based on their records from 10 years to 7 years. And if you now put a gloss on this statute and allow discovery rule and equitable estoppel and anything else to move it back, some of that depends on the actions of the plaintiff, not the actions of the defendant. So it really isn't the way the statute was written, and it says nothing about that. And that would put a gloss on the statute that's not proper. It would be the court legislating a new provision into this statute, and it shouldn't be done. So that would be my argument on that point is, unless the legislature said you can have, more time, it seems to me the clear import of the statute is to give only 7 years from the breach. That's what they did that for.
Counsel, how do you respond to your opponent's argument that they assume there is zero balance on the mortgage, so why should they do anything? In fact, a lawsuit might have even been premature, no harm if there's no dollar lien.
Well, the first thing I'll say is nowhere in their petition do they say that. That's Mr. DeVolder's gloss on the petition. And, they tell us we can't pick up facts that are not in the petition. Well, but they get to do that, I guess. Secondly, this note, according to them, they used the line of credit to pay off the $800,000 note. So they didn't have to pay it. So they had to know that something funky was going on there. And then they spent 3 years listening to these guys tell them they were going to release the mortgages. I mean, that doesn't make any sense. It's just not a reasonable way to do things, especially when you're talking about $3 million of loans. So, you know, to just assume that it's zero and never ask a question, that doesn't make any sense. And it's not in the petition. So, you know, they keep telling us the bank never gave a reason for releasing these mortgages. I mean, do you think you would sit there on you know, $2 million worth of property that you couldn't use for 3 years when the bank would not give you a reason why they were releasing those mortgages? That makes no sense. It's just not a reasonable claim. And so equitable estoppel does not apply. You know, it just doesn't. And the other thing I wanted to talk about is on the publication claim. Again, you know, they said that that we never told them about these mortgages, and so that there was no way there could have been a publication. Mr. DeVolder says that recordation should be assumed, and again, you're not supposed to assume facts that are not in the petition, and they have not alleged or shown in any way that these mortgages were recorded and would have been published to someone else when they in fact didn't even know they were there. That doesn't make any sense either. So from my perspective, if you read the petition and you stay within the four corners of it, these claims fall within the statute of limitations and or do not allege the proper elements, and so they should be dismissed.
Thank you. Anything else, Mr. Ogden?
No, Your Honor.
Thank you. All right. The matter of Benskin versus West Bank is hereby submitted. And bailiff, you may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.